Hello everyone. Today we will discuss Salomon versus Salomon Amp Company Limited. Every company has its own identity, a separate legal personality known as SLP, and this aspect of a company is a very important and fundamental element of company law. It is regarded as the most comprehensive and consistent law of corporate jurisprudence since it lays the groundwork for the creation and operation of a company. On the other hand, the rule of SLP has traditionally been fraught with controversy and is one of the subjects of dispute both inside and across jurisdictions. The concept, established in the case of Salomon versus Salomon, is still widely used and is traditionally praised as the framework of both English company law and the entire system of international commercial law. Now coming towards the facts of the case, stating that, for many years, Aaron Salomon successfully ran a profitable leather business. He decided to change it into a limited company in 1892. At that point, Salomon Amp Company Limited was established with Salomon as the managing director, along with his wife, daughter, 4 sons, and wife as members. For £39,000, the corporation bought Salomon's business. A charge over all of the company's assets totaling £10,000 in debentures, £20,000 in fully paid up £1 shares, and the remaining £20,000 in cash were used to pay the purchase price. Salomon possessed 20,001 out of the 20,007 shares issued, and a family member held each of the other 6 shares. The business had problems almost immediately, and a year later, the holder of the debentures, Salomon, having sold his shares to another party, hired a receiver, and the business entered liquidation. As a result, the liquidator filed a lawsuit against Salomon, holding him responsible for covering the company's trade debts. The issues of the case can be summarized into 3, namely: number first, whether Salomon Amp Company Limited indeed existed as a company. Number second, whether the company, an artificial invention of the law, had actually been properly constituted under any circumstances. And at last, whether Salomon was accountable for the business's debts. The first judgment was by the Court of Appeal. The court declared the company to be a myth, reasoned that Salomon had incorporated the company contrary to the true intent of the then Companies Act, 1862, and that the latter had conducted the business as an agent of Salomon, who should, therefore, be responsible for the debt incurred in the course of such agency. The House of Lords, however, upon appeal, reversed the above ruling, and unanimously held that, as the company was duly incorporated, it is an independent person with its rights and liabilities appropriate to itself, and that, the motives of those who took part in the promotion of the company are absolutely irrelevant in discussing what those rights and liabilities are. Thus, the legal fiction of corporate whale between the company and its owners, controllers, was firmly created by the Salomon case.